the breaking news is word from Hunter Biden's attorney that Hunter Biden will not testify in the federal gun case against him. This means that we could soon hear closing arguments and the jury could soon get the case. Let's go right to CNN's Evan Perez live outside the court. Bring us up to speed on what has happened.
Well, John, the jury is still not in the room at this moment, and the prosecution and the defense could get to their closing arguments as soon as that happens, as soon as the jury is in the room. But as you pointed out, Abby Lowell, Hunter Biden's attorney, no surprise here. Let's be honest. Indicated in the pre-trial hearing just now that he doesn't believe Hunter Biden will testify. The formal word will come when the jury is present, and part of what they're arguing right now behind the scenes is what jury instructions, what the jury will be told about all of this. One of the things that Abby Lowell got agreed to was that the jury will be told that you can't hold it against the defendant for not testifying in his own defense. The judge, though, has pushed back on the defense's efforts to add more language to the jury instructions that would be more favorable to Hunter Biden. For instance, the idea that he didn't knowingly violate the law, which is something the defense is really all about. And they also wanted they also want to make the argument that Hunter Biden did not think he was addicted to drugs when he bought that gun in October of 2018. That's the reason why we're here and why Hunter is facing these 3 federal charges that could send him to prison if he is convicted. But as you pointed out, we could very much have this case in the hands of the jury today if Hunter Biden does not testify. And John, I mean, the fact that we're here, we had about 10 witnesses. I think 10 witnesses over 4.5 days of testimony on the part of the prosecution's case really is what the jury is going to be considering after all of that.
I appreciate you giving us sort of the real-time description of what's going on inside the courtroom, because the attorneys are just having these discussions with the judge right now. Can you talk to us a little bit more about the jury instructions that Abby Lowell did want but didn't get for the defense here? And it does have to do with what is their main argument. They are making the case that Hunter Biden did not think when he signed the documents that he was addicted to drugs right then.
Right, John. This has been really the focus of the defense. They have tried their best to point out to the jury that what the prosecution has brought on so far does not show that Hunter Biden was doing drugs in the month of October of 2018. You have text messages, you have testimony from September of 2018 and November of 2018, and so that's what they're trying to focus on. And what Abby Lowell was trying to do was to make this more clear in the instructions that the jury is going to get, the form that they're going to fill out when they vote on guilty or not guilty. The judge pointed out that the instructions that they're going to get when they get read out to them will have the word knowing in there. So that's the reason why she said it was not necessary to put this more fully in the form that the jurors will get. Lowell has not won very many of these arguments with the judge, so it's not a surprise that he didn't get his way. But from the prosecution's point of view, they believe that what the law simply says is that he was using drugs around the time that he bought the gun. And so that's where they are going to focus their argument when we get to that this morning. John?
All right, Evan Perez, keep us up to speed. Let us know when the jury is back in the room, and frankly, what happens next inside there. Thank you so much. Kate?
Absolutely. With us now is former prosecutor Jeremy Salam for more on this. All right, let's talk about jury instructions, because I think that's really interesting in a second. But first, just your initial reaction to all indications now pointing to Hunter Biden not taking the stand.
I'm in shock that nobody was an attorney, and for that matter, probably many people in the public. You want to testify because you think that's the best evidence, and it very well may be, but there's so much impeachment material, there's so many things to confront him on, not just what other people have said, but his own words, his own actions. Evidence is really strong against him, so it's a smart move, but I'm sure he wants to say, I wasn't using drugs then, I was not addicted.
That's what I was going to ask you. What risk outweighed the benefit here in the end, do you think, with regard to him taking the stand?
Well, Lowell is trying to make the argument we just heard that at that moment he was not addicted, and he didn't believe he was addicted, and he was clean during that time, and you heard from his daughter that he was doing well, even though she was impeached as well.
Right.
But if you get up there and all of a sudden you open that door and you're going to be asked, well, isn't it true you did this? And then there's this, and then there's the image, and there's the book, and there's the residue from the cocaine and the crack cocaine, and there's a crack pipe, and there's so much that they're going to build and build and build, and before you know it, your credibility is shot. And right now, if we believe what we have read, that you had one juror, for example, who was crying and in tears, there's a real opportunity potentially at a nullification, or maybe hanging someone. You get in there and you lie, it's not good.
It's a great point. So let's now get into this discussion that is happening, kind of argument in court right now, regarding jury instructions. We know, especially from very recent past, jury instructions, the language of the jury instruction is so important to how things proceed when they go behind closed doors. Abby Lowell, Hunter's attorney, agreeing to allow the judge to give an instruction to the jury that they shouldn't hold it against him, that he did not testify in that case. But then this discussion about what additional language or not can be, will be added with regard to the instructions. Why does this matter so much?
Well, it shouldn't be just should, it should be can't. He has a right to testify, he doesn't have to testify. And we should not take an assumption or presumption one way or another. That's so critical because you cannot use your lack of words against you. That's not fair, and no one should be judged that way. And the law and the Constitution says that. So that's number one. Number two, I almost forgot the question, but...
with regard to, they're fighting now over what additional language in jury instructions. With regard, as Evan says, the judge has already said that the word knowing is going to be in the instruction, but Abby Lowell is pushing for there to be more.
Because Lowell is hanging his hat that at the time when he meaning Hunter Biden, was filling out that form, he wasn't knowingly an addict, he wasn't knowingly an abuser of drugs, and if he was clean during that time, and you've heard evidence from moments before and maybe moments after, but during that moment in time, he was sober and he knew and believed he was, didn't believe he was violating the law, that is so critical. That goes to the heart of their case. That is really, the depth of their case, believe me when I say he did not know.
This just made me wonder, when it comes to closing arguments, you can lean on a lot in terms of thematically in your closing argument, but for the defense, do you lean on the lack of pinpointing him being on drugs at that moment with the jury, or do you lean on more of the emotion that we have seen come out and the relatability?
They're not mutually exclusive. You can absolutely, you should lean on the fact that the evidence corroborates that he was doing drugs or was addicted potentially. And that term is very vague, but he was addicted to drugs at time A, B, and we'll say that the gun possession and purchase was time C, and maybe at time D, but at time C, at that moment he wasn't. And even if you may believe he was, this is a common problem that we all have to deal with in families and friends and people we love. Addiction is scary and frightening, and you lean on that too to paint that whole picture.
What you're kind of pointing to this, the likelihood of a hung jury in this case is what, do you think?
I can't give you certainly a number. It doesn't really work that way. But it's much, when people were talking about potentially the hung jury in the Trump case, there's no emotional component. There may have been a political component there, but there was no emotional. It didn't tug at your heartstring and say, I know somebody who falsified records, and they were really, it was really sad and terrible. Look, I clutch my chest. But you can say, I know somebody who had a horrible addiction, and they're good people and a good person, and it's disease, and they, made really bad mistakes, but should they be held accountable in perpetuity for it? No. And that's the kind of thing that you would pull onto.
It's really interesting. I'm really curious as to how this all plays out now. It's great to see you, Jeremy. Thank you so much.
Now let's continue this conversation. Joining me now, CNN senior legal analyst and former state and federal prosecutor Ellie Honig, and defense attorney and former federal prosecutor Shan Wu. Ellie, your take on Hunter Biden apparently not taking the stand.
Absolutely the right move. Absolutely his right. It would have been way too risky for him to take the stand. There's no upside. And to the extent the defense wants to make the case, which they do, that, the prosecution does not prove that he was an addict at that key time in October 2018. They've already done that. They called Naomi Biden, Hunter Biden's daughter, to the stand. She testified that as far as she knew, he was sort of in recovery then. She didn't see him using drugs at that point. That's more than enough if you want to make your defense. It's the right move not to call him. It's a constitutional right not to take the stand. They did the right thing.
Good call, Shan, you think?
Yeah, I think it's a sign. When they don't call the defendant, there are different reasons, different sort of atmospherics that come from that. Here, to me, it's a little bit of a sign that the defense is feeling pretty confident at the moment, as confident as they can in a case like this. Putting a defendant on is sort of a Hail Mary pass. I mean, A, you got to think he's going to do really well, and B, you got to think we really need him to come across well to the jury. A little bit of a choice here for them, a tough one, which is they think the atmospherics have been looking pretty good. I mean, the First Lady has been in the audience, there's a lot of sympathy going on here. So, as a lawyer, you're thinking, defense counsel, am I going to regret not putting him on if there's a conviction? Or if there's a conviction, am I going to think, might have done this as an acquittal, but for the fact that he didn't do well? So I think they're feeling pretty good right now, as well as they can be, and no need to take that risk.